to tonight's event, Estate Planning, Lessons Learned During the Pandemic. Tonight we are joined by Bryan MacAvoy from the Smolin Plevy Law Firm. Just a quick note up top, Bryan is a lawyer, but he is not your lawyer. And this is not legal advice or an establishment of a client-attorney relationship. Any advice Bryan gives you tonight can be used to help you find a lawyer or do some things on your own. And it's just meant for general education. So please just be aware when you do ask questions tonight, because he is here to answer some questions, just be aware he is not your lawyer and he's not acting in that capacity. But to that end, he will be taking questions tonight throughout our presentation. So if you have questions for Bryan at any point tonight, feel free to put those in the chat box or the Q&A box, and I will make sure they get asked of Bryan by the end of the presentation. So without any further ado, I'm going to turn it over to Bryan.
Well, thank you so much, Hannah, and thank you all for joining us tonight. If you've been here a few minutes, well, you know we've talked a little bit about the icebreaker on the screen. If you're just joining us now, well, we have a little icebreaker. Once again, I cannot see you, I cannot hear you, but if you have some answers to what's your favorite restaurant or takeout, and again, this is a bit of a little cheat code. It's a way for me to find some great new places to try out. But you can put that in the comments, let us know. And then in general, it's just meant to get your mind working a little bit and get you familiar with that chat box so that you can send us your questions. Well, again, I want to thank Hannah and the Alexandria Libraries for hosting us. We've actually done a few of these seminars. I was a guest when we were doing these in person and even had one scheduled well, about a year ago now. It was scheduled in person and then we went to Zoom. So we've continued these, and tonight we'll be doing a bit of a lessons learned from the pandemic from a practitioner's perspective. I will give my answer to get us going. What's a favorite restaurant or takeout? My wife and our two daughters, well, we have a weekly pizza tradition, and Fairlington Pizza, who delivers and continued to deliver, has been a bit of a lifeline through this pandemic. So I know it's a little bit of a general answer, but yes, I'm from New York. A good pizza really kind of takes me back home. Though now that we're getting a little bit back in person, we've been able to go to the Block in Annandale, and Snow Cream has some of the best ice cream, including a March special Lucky Charms ice cream for the St. Patrick's holiday. So that was fun. Well, I want to point out the information to reach us. If you kind of think of a question afterwards, do feel free to reach out to us here in our Tyson's office. You see my email address there, and our phone number and the website. But as a little bit of a background, I am an attorney here at Smolin Plevy. I do estate planning, wills and trust administration, and a little bit of litigation as well. Yeah, we've been doing this series with the library. I think I've been doing it about 5 years now, back when I was doing this as a solo attorney as well. I want to tell you that a couple of the topics we'll cover, they're a bit heavier. We're talking about setting up a will, perhaps, and what happens when somebody does pass away, the probate process as well. I understand these can be slightly heavier topics, but I'll do a couple things. I'll cut it with a little bit of humor here and there to help take the edge off a little bit. But then at any time when it does feel a little bit of a difficult topic to cover, I like to remind people that having a plan in place, which is what we're here to talk about, it empowers you to handle those difficult topics. It makes the topic less overwhelming, and And ultimately, well, it's a gift to your heirs and those that you leave behind. A well-structured estate plan, as we've seen, really helps with that challenging time. Um, well, tonight, again, we're here to talk to you about, oh, it didn't go. Estate Planning 202, Lessons Learned. Lessons learned from the pandemic, and you will see there Morgan on the left, Sage on the right, my two beautiful daughters, and yes, you're going to see more pictures of them throughout the presentation here. We'll talk about the lessons that we've learned from a practitioner's perspective and beyond, emerging trends, and maybe some of the things that actually have remained the same. As a quick background as to my journey to estate planning, I attended law school actually for a very different aim in mind. Well, we get teased a little bit. Everybody that goes to law school thinks they're going to be that swashbuckling constitutional litigator. Well, as it turns out, I did go into a field like that. I did appeals before the DC Court of Appeals, arguing Fourth and Fifth Amendment rights. And I found it very exciting. I had a solo practice where I was able to bring arguments before the historic DC Court of Appeals. But it was a few years down the line when Sage and Morgan joined the family. Our two beautiful daughters were born. My wife turned to me and said, "We don't have any wills. We probably need to nominate guardians. You're the lawyer. Go figure that out." So I did. I spent some time hitting the books, brushing up on my wills, trusts, and estates. And the first estate plan that I did put together was our own. Now it's been updated since, and we'll actually talk about that. How long should you go before updating? And to back up a little bit, well, if you are one of those 65% that do not have a will or any estate plan, you don't have to raise your hand. And again, I can't see you, but the truth is a lot of folks have not set up their estate plan yet. And we'll talk about that as well. All right, another good lesson from law school. Conclude first. Go right to your message. What are those lessons learned from the pandemic? These are going to be a little bit bullet point form, and I'm putting them up front in part because we're going to talk about them as we go a little bit more through the substance. But we'll talk about those bullet points now. First, there have been trends toward remote everything. You might be working from home. You might be doing a whole lot of FaceTime with the grandparents. And so that is not just, of course, in our wills, trusts, and estates world, but that has been the whole world. We've actually seen in our practice a major trend toward remote notaries, which have made things a bit easier. Probate appointments for the initial appointment of an executor. Those can be, remote, though some of them have not. We've been seeing institutions work a little bit more with PDF copies rather than the original copies with the original signatures. And so there has been that general trend. What are some of the limits of remote? Well, one of the very first big ones, and we'll call this back when we talk a little bit more about wills in particular. An original will is still that gold standard. A probate court is going to want to see that original will. You can petition to probate a copy of it, but the general rule is that they're going to need to see that original will. Now, up front, March of 2020, that became a real problem because how are we going to do that? We still didn't even know if this is something that can we mail the original will, or are we dealing with a virus that transmits that way? So that was a major problem right up front and a major roadblock that we had to learn to navigate. And so in addition to having the original will, signing an original will. If we're going to hold a signing and we can't gather to do it, well, what are we going to do? We have been able to do remote signings for some things, but a will does need an original signature. This cannot be one of those perhaps contracts you've signed that have been those e-documents, e-signatures. A will cannot be signed that way, though we have started to study whether this would be accepted by a court, and perhaps with a petition, perhaps a court might even be able to rely on that. We like to err on the side of a document that we know a court is going to be able to probate. And so that is what we prefer to do, and an example of a limit of a remote signing. Another limit of remote everything. Well, I will confess, I'm not a huge fan of Zoom. Yes, I know I'm saying that on a Zoom presentation, but I think you've probably heard your favorite comedians joke about how tiring it is, how exhausting if you are in a line of work that does a lot of meetings all day. I'm in Zoom meetings. That can be a limit too. But here's one of those reminders about how we can kind of get through these. My wife likes to tell me that if you can tell a joke, reset the mind. It gives you energy. It allows the lessons to come in a little bit easier. And so, yes, I have a bit of a dad joke to present. So I want to talk about grandfather clocks. Have you ever seen a grandfather clock? It's one of those big stand-up ones with the big face on it. Have you ever tried to eat one? It's very time consuming. Ooh, I'm sorry. But there's Hannah. Well, hopefully you're getting a little bit of a chuckle. I would like to promise that my next joke will be better. It will not. They'll all be about that bad. But perhaps that's the energy to get us through another Zoom meeting. Now, the final point I'll make, planning, the emphasis that we place on planning, that has been affirmed. It's a great idea to have a plan in advance. The best time to do it is to have done it already, and the second best time is now. Perhaps another time is to find a window. If you don't have an estate plan, if you haven't been able to look into this, I understand. I am a father of two daughters, somebody working, trying to navigate a brand new set of challenges. I am living that as well. But to the extent that you can find a window because I know this is something that has to be done on top of your long list, but to be able to put a plan in place actually can take a lot off of your mind. And we have seen for those who either have, if they had a trust in place, to be able to amend it is a lot easier than to have to start from the beginning. And for those who have passed away, a well set out plan has met the challenge very well. Okay, going to keep moving on. Well, generally what we are talking about can be divided into two categories. What would happen if something happened to you, both in the short term and in the long term? Here's another one of those instances where hopefully I'll be able to provide a little bit of levity to a heavier topic. We'll talk about in the short term, what happens if something happened to you, and this story is going to have ultimately a happy ending. You are going to one of those favorite spots that you like to go to. Now that we're going back to restaurants in person, one of my favorites has always been Hank's Oyster Bar. And so my wife and I love to go there when we can get away for a mommy and daddy date. So here we are at Hank's Oyster Bar. In walks a traveling salesman who sells that sleeping gas to the dentists. and he didn't have a chance to store it in his car. He brings a canister right in. It's been a long day. He's very tired. He trips, he falls, his canister falls over. The whole place fills up with sleeping gas, and we all fall asleep immediately. Now, for my wife and I, tired parents, this is actually wonderful. We never get to sleep. We're going to have the best rest we've had in a long time. But the thing is, we are asleep and we are incapacitated. What does that mean? Well, basically, we couldn't tell you, if funds needed to move from here to there, what to do. If we have to go to the hospital, have a checkup. Is this person doing okay? Well, I can't give the doctor advice as to medical procedures. I need a plan for the short term. Again, the happy ending to this story is we're all going to wake up from this and we're going to be just fine. But we have possessions, assets, and we are not in control of them, at least for the time being. What governs here? Well, this is a list of some of the documents that govern during your life. Of course, we're going to talk about another category, what governs after you have passed away. But here, we're going to talk about powers of attorney, both general or financial powers of attorney and healthcare powers of attorney. An advance medical directive, sometimes called your living will, and a little tease for another document that governs during your life, a trust, a living trust. We're going to talk more in depth about that when we get to that category, but that is a document that falls under this category as well. A little bit more detail about some of these. The healthcare power of attorney. This grants a limited power to your agent to give voice to your health decisions. It often operates in connection, in concert with your healthcare directive, your living will. It is springing in nature, and by definition, I'm going to pause here to talk about what that means. Well, if I were to name my brother my medical healthcare power of attorney, it doesn't mean that he could, while I'm conscious and awake and fine, he could stand next to me and say, all right, doctor, my brother needs an operation to, remove that mole on his nose, that kind of thing. No, I am awake, I am conscious, I will get to make that decision. However, if I am incapacitated, my nominated agent will help give voice to those decisions that I have already set out in my advanced medical directive. Now, this is only during your life. And this is one of those things that we will talk about across all of the documents. When is this document in operation and when is it not? When does it no longer have force? The general power of attorney, similar points here. It's sometimes called the financial power of attorney. This governs more your financial assets, though it goes far beyond that. It will enumerate several powers: power of sale over your real estate, the power to control your financial personal belongings, your financial assets. More and more important as we live a lot of our lives, online. Now, existing power of attorney versus springing general power of attorney, you can and should tailor this document the way that you want it to be tailored. Does this give an existing power to your named agent, or does this power only come into force when you are incapacitated? Your document can and should say which one you intend. And in working with clients, we make sure that we're clear about those powers and how they want theirs crafted. Now, it grants power to your agent to control assets, belongings, even property. And so it is a broad grant of power. We, in working with our clients, really make sure we accentuate that. We let them tell us They know the people in their lives better than we do, but we want them to know what this power grant is and what it means. Now, it is only during your life. A general power of attorney, and this is a misconception that we often hear from folks that do give a call into our office. I've been given a general power of attorney, for my brother, and he just passed away. Well, that general power of attorney has no more force. Okay, it is not a document that governs it anymore. It is only during life. And it's not always respected by institutions. It gives power to your agent, but if that power, if that document is presented to an institution, there is a chance, slim, and it's not something that happens all the time, but it does happen, that it would not be respected by that institution. Okay, example granted, my wife and I from Hank's Oyster Bar, well, it's 5 days later and we're still asleep. Now, again, I'm loving the fact that I'm finally getting rest, but bills need to be paid. Perhaps I'm, in a short-term care facility, and that needs to be paid for. Money will need to be moved from this account to that account. My named agent, perhaps again my brother, is going to bring that document to the bank and say we need to move X amount of money to Y account to pay for this. Why would that bank not respect that? Well, perhaps I signed this too long ago. This document, the institutions are going to be a little bit worried about, can we rely on this document? Did this person fill out this document so long ago that this is not something that they intend to be a power grant anymore? Was it filled out too recently? Did this person have capacity to sign this document? Perhaps we're talking about somebody in declining health, and that declining health included a mental decline. Did they have the capacity to sign it just days ago, and now they are in a coma, or it's been a declining health situation? Can we rely on this and not get sued? And so those are some of the examples as to the limits of that. I'm going to move on to the next slide, and then maybe I see some questions coming in. We can take a pause after that. But this was that other document that I teased a little bit. What in the world is a trust? I know that you've heard the term, but this is another one of those ones where I find that people have some misconceptions about what this actually is and what it isn't. Well, a general definition is it's a three-way agreement between, during your life, you and you and you, right? The same person. You are granting assets into a trust. You, during your life, have control over those assets as the trustee, and you are also the beneficiary, right? Those assets are for you. You put them in, you get to control when you take them out. You are the person sitting in all three of those seats. I like to give the analogy of it being a little red wagon. And this, probably comes from me being a dad, but of course, my two daughters have the good old radio flyer wagon, the red wagon, where they carry it around, and actually they like to put their stuffed animals, their stuffies, as they say, in them and wheel them around. Are they holding the stuffies in their hands? No, they're in that wagon. But do they have them in their control, in their possession? Yeah. They can take them out anytime they want. And here, the trust, being that wagon, comes with its own little instruction booklet. Should anything happen to me, my little red wagon has an instruction booklet as to what should happen. And that's not necessarily talking about should something happen to me in the way of my death, but in my incapacity. And so here you are giving that power to the trustee. You would list a successor trustee to control those assets after you. And Perhaps going back to our Hank's Oyster Bar scenario, I finally wake up. I'm good as new, in fact, even better rested, and I can take back control of my assets. Now, a trust can replace probate, as you see in the next line, because say in a different scenario, I have passed away, that trust comes with a set of instructions as to where these assets should go now after death. But it can also handle incapacity, as we just talked about. So it is one of those documents during your life, and in fact can help you in place of the, well, I shouldn't say in place of, similar to the general power of attorney, it can handle incapacity. Well, I have seen some questions come in, and I think it's a good time to take a pause and field some of those.
Thank you, Brian. I'm going to start with a couple questions submitted by Robin. The first question is, should I bring my appointed executor, a backup executor, added to my checking account as ones who can write checks on my account? So I'm not entirely sure if this is asking if she needs a backup executor in addition to an executor, or if she should go ahead and put those people as people who have access to her checking account now before anything happens to her.
Right. And I'm going to just call back the caveat up front. This is not official legal advice. Additionally, I would, if this were a consult, I'd probably have several follow-up questions just to clarify it, but that is not a punt. I will give a couple concrete responses here. And I will do it on both sides of the coin. First, naming people to your bank account in a couple capacities can be helpful. If you name somebody as a joint owner, it does a couple things. Yes, it can empower that person to write checks to help make sure assets get to where they need to go. A joint bank account has an automatic survivorship so that asset, and we'll talk a little bit more about this when we go through, actually the very next slide is going to start to talk about probate. It will not be a probate asset because it never fell out of somebody's control, okay? It was not in your name alone. And so we'll clarify that when we go through the probate side. Now we'll get to the other side of the coin and give the caveat. If you did not intend to leave this asset to that person, rather you wanted it to be part of your full estate and be distributed just the way your will says, well, unfortunately, that asset is not going to go that way. It's going to go to the joint owner who has a right of survivorship, likely. Now, that is in the letter of details with the bank or other institution. And so this is both a good way to make sure an asset does not go to probate, but it is also a way that that asset is not going to go to probate and be distributed the way your will directs. And so it's the type of thing where we advise clients very closely, you know, what is this asset? Where do you want it to go? And make sure that this does not go in a direction that our client does not want it to go. A good question there.
The next question from Robin is, Robin wants to donate her body to science, preferably a teaching hospital. She went to George Washington University and she asked them if they would take her body since they were her alma mater, and she got no response. How can she donate her body to a teaching medical school? Is this something that you would cover in a will or a trust? Is this even inside your purview as an estate planning attorney?
The short answer is yes. Yes, this is absolutely something that we talk about with our clients, and we typically can put a clause in there, tailor it to our clients' aims. It sounds like Robin went an additional step, which is great, to contact an institution to see if that is something that they might do. A lack of response, I try not to jump to too many conclusions. I know people are working from home and that kind of thing, and emails are not being answered in the normal time, perhaps, but it's worth following up on. What we sometimes do when we are similarly donating funds to charities, we might put language in there to the extent of, I want to give it to this specific charity, or failing that, such similar charity as my, in a will, executor might in their discretion decide, or if it's in a trust, such similar charity that my successor, my trustee might decide.
All right. Our next question comes from V. V has the question, do you recommend using the National Advance Directive Registry? There is also a Virginia Advance Directive Registry. And do you have any experience with that? Are those things that you would put in a will or an estate plan?
Yes, so an advance directive is absolutely something that we typically include in pretty much every estate plan. Though the focus of this question seems to be, a registry of it. I have heard of it, and I have discussed this with a couple clients. What we on our side want to make sure that we do is we provide that to the client and give them advice as to make sure you talk to the people named as your, well, basically across your estate plan, successor trustees, executors, and then specifically in the medical powers of attorney and the advanced medical directive, talk to those agents that you have named to make sure your wishes are carried out, to clarify with them, right? These are my wishes, and this is something that you are helping me achieve my goals. Additionally, we provide extra copies to make sure that our clients can provide them to their physicians. And so it's a great idea for your primary care physician to have a copy or know about it. And if you have any doctors that you see on a regular basis there too. And those are really those avenues that we make sure our clients know about.
All right, thank you. We have a clarification from Robin about her question regarding putting executors or powers of attorney onto bank accounts. She writes, I have no one in my family to handle affairs. I have instructions of how to, in my working will, to say how I want power of attorney and executor to pay outstanding bills and distribute remaining funds to charity upon my death, etc. I was thinking they needed to be on my checking account to handle this. So if I die with a checking account and no one else is on it, how is my husband or my executor able to access that money to distribute it?
Great. Okay, that absolutely does clarify the question, and thank you, Robin. So essentially, here, no, we would not want someone to be on that checking account with you, again, because that might interfere with the distribution of the assets from the will. How does that person gain access? And that's a great lead into our next area, talking about probate. The short answer is somebody is named your executor, or the title is different in different places, personal representative. And once they get that appointment, they are essentially standing in your shoes. They get a letter of administration, letters testamentary. Again, that title is different from jurisdiction to jurisdiction, but in short, it's a piece of paper with one of those good old raised seals and embossed signatures saying essentially they are standing in your shoes now. They control those assets. They can write those checks. They can direct the assets as the will directs. They can sell property. They stand in your shoes, essentially. And so that's how that would work. So it does not require naming someone as a joint on a bank account. In fact, that might interfere with the distribution. I'm not saying that's a bad way to go. It's actually quite helpful if there's an account that you don't want to go to probate. Naming a joint makes sure it does not do that. Or if you name a beneficiary on death on an account, that also helps make sure that asset does not go through probate. But it's something that people should be aware of when they are naming those beneficiaries or joint owners.
If I die without a living relative or without a close friend, who do I name as my executor? Like, do I need to personally know the person? Could I name you as my lawyer as my executor?
What is typically done by some folks is to name banks and trust companies to do that. Either corporate trustees or executors will carry out those, and it can be helpful to have essentially a third party doing that. There are attorneys that do that as well, yes, and they can make sure that gets carried out. And so, yes.
Jill has the opposite problem. She writes, I cannot decide which of my two children to have as my executor, trustee, etc. Is it a bad idea to name both children for the above roles?
In short, not necessarily, but this is another one of those ones where if this were a consult, I would have several follow-up questions to ask. Some of them would be, are these folks that can work well together? If there is one that has you don't need to have any background in any of this stuff, but if there's somebody that has an ease and facility in working with financial institutions or bureaucratic red tape sometimes too, those are helpful skills in the field, but again, not necessary to it. And people who have been appointed or are looking to be appointed hire our firm to assist through that process as well. All of this is to say that it can be a very case-by-case basis. Here I am going to give you a big old punt, but we have put together documents in both categories where we have helped our clients reach a decision, one versus the other, or yes, it can be appropriate to name joint executors or trustees.
We have one more question for right now, and then I'm going to let you get back to your presentation. So if any of you in the audience have more questions, feel free to put them in the chat box or the Q&A box, and I'll get them asked at our next question break. Our last question from right now comes from Harvey. Now, Harvey is a regular in my death cafe that I host every month. So if you like talking about death or dying, come join us. We're not lawyers, we're not experts, but we do like to talk about it, and you can learn a lot from your peers. Harvey's question, I'm a little unsure if it's exactly under your purview, so let me just take you through the broad strokes. I know that he recently put together an estate plan. So he writes, I wonder if there's a way to calculate total depreciation on a shared house. I've rented out 75% of my home since 1997, and that rental period will end in August of this year. I looked at my 202 depreciation on Schedule E, and it was around $4,500. In 2010, it was about double that. I don't have handy notes from before 1999. The question is, can the total depreciation claimed be gotten from the IRS or extrapolated out from past tax returns? And I'm not really sure how that goes into wills and trusts. So I'm going to leave that to you to decide how to answer.
Sure. This one's largely going to be another punt, so I will give you that caveat up front. While our practice area does overlap quite heavily with the general umbrella category of taxation, And so that's why, questions about tax are certainly not out of bounds. It's something that we do consider in the planning process. Something like that, we work in tandem very closely with accountants. And so we've got a whole list of folks that help us out. And that one we would make sure for our clients' purposes, they would get a solid answer on that one. The types of taxation, we look a little bit more carefully at are the estate tax, gift taxes, generation skipping taxes. And so again, ultimately, I'm giving you a punt here, but I am saying taxation is definitely a category at the table when we are putting together estate plans.
If people in the audience have questions about taxes and how that would impact their estate plan or their plans to make an estate plan, is that the type of thing that they should seek out an estate planning attorney for, or is there another professional that they should seek out?
It would depend on what category we're talking about, but it absolutely is the type of thing that is part of the conversation when we have pretty much every consult. And we would be able to help our clients reach, oh, is this a tax question that is addressable in the estate plan, or is this somebody that we can call up one of our accountant friends to make sure to get you the answer there. But in general, going back to one of those initial points that I brought up, it's always a great time to plan, right? It's always a great time to start getting those questions addressed. And it's definitely part of what we do here.
All right, so that's our last question for now, but if you in the audience have a question for our next question break, feel free to throw that in the chat box or the Q&A box.
All right. Well, thank you all for some great questions there. And as long as I can keep us moving at a good enough clip, we'll try to address a few more of those at the end as well. Well, we're going to move into the next category, and this is the probate process and intestacy. Now, this is that other side of the question. What happens if something happens to you here in the long term? And we're talking about after you pass away. What happens? How does that work? Probate can be one of those terms that gets a little unduly scary. I think we speak to a lot of people that want to say, I want to avoid probate. Well, it's not necessarily that scary process that it's been turned into, although it can be a valid aim of avoiding probate in an estate plan. So we'll talk about what it is, what it isn't. Generally, it handles your assets when you cannot. The questioner that asked about, what about who's going to control my checkbook after I pass away? Well, it'll be that person appointed to be the personal representative, the executor. Typically, it is going to be a will, though it doesn't have to be. When somebody passes away without having written a will, they are called intestate. They do not have a will. Probate, that actual word itself, comes from the Latin root word, to probate is to prove. And so what that process is doing is proving that this will, this document, is the will of the decedent, the person that's passed away. Now, some of the concerns, some of the considerations at play are time, costs, privacy. It can take quite some time to make sure that these assets go to the beneficiaries listed in the will. There can be fees associated, there are fees associated with that process. And it is a public process. And so privacy is a concern. That document will be made a public document. And so folks who would like to avoid that might put together an estate plan that does do that. Again, calling back to the trust, which we'll talk a little bit more about what that does on this process. A little bit more about wills first, though. The intestacy statute is a statute, it's a law in every jurisdiction, every state. basically saying what happens if you have not written your own will. And it generally, although intestacy statutes are different in different states, it's generally what we describe as the sweetheart will. If I pass away, everything goes to my sweetheart, my spouse. If there is no spouse, then to any children. If there are no children, then it starts going up the ladder until it reaches beneficiaries to whom go the assets. Now, what is in a will? Typically, you are going to name your executor or personal representative who's in charge, beneficiaries who it's going to. You can nominate guardians for any children, underage children in your will, and a few other things. What isn't in a will? And this is a good question here because, well, say you have one of those accounts that we were talking about earlier, a big old life insurance policy that you have been, that you have had in place to make sure that the people you leave behind are taken care of. Well, a life insurance policy, a retirement account, a lot of these big assets where increasingly a lot of our assets lie, they typically have beneficiary designations on them. Kind of like that radio flyer wagon that I talked about that the trust is, it comes with its own little set of instructions, a little instruction book. What happens? Where do these things go when I die? Now, you can go ahead and write in your will, my big life insurance that I have been saving up for, I want to make sure that goes equally to my children. Okay. Or here another specification. Actually, I want it to go to one of my children because I know they have a little bit fewer assets. I want to make sure that child is taken care of. Well, if that is only in your will and that asset instruction booklet says something different, if you named somebody different as your beneficiary designation, that beneficiary designation on the asset itself is going to control. The will does not. So what's not in the will? Well, you don't get to say where any of those assets go if you have written beneficiary designations. Those control. They operate more like contracts that way. And so that's a caveat that we really make sure that our clients know. We talk about all of the assets that they have, where they want them going, and how that should work. Okay. Now, a little bit more about estate planning during COVID-19. Some of the challenges we've seen, and this is something that I put into a previous presentation, but I thought very, germane to what we are talking about as far as lessons learned. One of the big ones, one of the big challenges, signing the documents themselves, right? When we have been experiencing a challenge where, well, it's not quite safe to gather indoors. Thankfully, we're easing back in that direction, but for a long time, that has been the major challenge. How did we used to do this? Well, we used to gather a whole bunch of people to make sure we had witnesses, a notary, the people signing. Sometimes we're having a husband and wife do a signing. Well, that's more people. And so we would gather a whole bunch of people into an enclosed space, and man, have our views changed on that, haven't they? Well, how are we figuring that out? A number of ways. A couple times we've done outdoor signings as we found out that they were safer. Other times, if we have a document that does not require an original signature, we can do a remote signing using e-signing or an e-notary. We also have a room that has a wall of windows so our witnesses can be behind that, whereas the people signing are in the room, and it has a separate entry. We have gotten creative. Hopefully, we are easing toward a direction where that is less a challenge, but that is kind of one of those points I said up front. Planning and finding a window when it can be done is absolutely something that we recommend. Now, second point, the good news, much of the process can be remote. setting up an estate plan, we actually typically do an initial Zoom call to meet with the clients. As we send out drafts, that can be done through the mail, or we can send PDF copies. Getting feedback from the clients, that can be done email, phone, or follow-up Zoom. We do need to get those documents signed, and especially when we're talking about a will, we want an original signature on there. But a lot of this process can be done remotely, and we have actually learned, as many other practice areas have, a good amount of that process can be done that way. All right, and so here's our summary, some of the points that we've touched upon, the lessons from the pandemic, including that humor can help ease a situation. And so, yes, here comes another one. This one's my daughter Sage's favorite one. Hannah, why did the man fall into the well?
Why is that?
Oh, because he couldn't see that well. I did warn you.
Ew.
Well, oh, there it is again. Other points we covered: powers of attorney and living will, documents that control during the life, and then sort of that in between one, trusts. A living trust, yes, does control during life, but can also provide instructions after death. And that way it actually is a good document both to do things during life and to direct assets and avoid probate after death. We talked about probate and intestacy, how it works, how a will works and the limits of them, what's in it, what's not. And finally, planning in the COVID-19 era, and hopefully, as we escape that, some lessons we can bring from it. All right, and I know we probably had a few more questions, and so a good time to address some of those.
Yeah, so thank you for those awful dad jokes. I thought the second one was better than the first one, but both caught me equally off guard, so thanks for that. Our first question comes from Kathleen. Kathleen writes, how soon after someone passes away does the executrix need to work with the deceased's estate attorney? How does the executor or executrix get paid, and what determines how much?
Excellent questions, and so I'm going to address several aspects of those questions. Executor, executrix, old terms referring to the different genders. So if you had not been familiar with those, good callback to those ones, some legalese ones. I think the first one was a question about how soon after. There is not necessarily a set time, but sooner than later for the nominated executor, executrix to start working on that for a number of reasons, not the least of which there are some both implications for either tax purposes or claiming life insurance, that kind of thing. So sooner the better. And then the probate process can just take some time. So if this is going through probate, then getting that ball rolling sooner is better. I think another aspect of that question is how quickly should I reach out to work with the estate planning attorney? That is another one that as close to immediately can be helpful in large part because especially, our firm and others like our firm, we typically have a good amount of information even beyond the copies of documents or sometimes the originals in storage, which our firm and others do offer. We have information about the assets that the decedent had. So incredibly helpful because that is a big part of the charge of the executor or executrix to marshal those assets and direct them as the will states. Speaking of as the will states, oftentimes a will state the compensation for the executor or executrix. In the absence of that, there are statutes and guidelines about that. But yes, several great questions within that.
What if I have no idea who the attorney was?
Mhm. So typically, we tend to put that in on our documents, and that is a good guideline. Um, there are, after that, it would be kind of the intuitive answers that you might think of. Does a family member or friend know? Is this a person that worked with an attorney before in perhaps some other field, and might they know? And so kind of follow the breadcrumbs in that sense. But estate planning attorneys tend to be pretty good about that as far as putting that information on the documents or on a binder itself.
What if, I'm sorry, I've got this fascinates me for a second. You got me on a roll. What if a loved one passes and I don't know who the attorney is and I can't find a will and it turns out there is no will? Who do I contact in that situation? Is that just call the funeral home and they refer me, or is there someone I'm supposed to alert?
Sure. So essentially, it sounds like this person has died intestate, meaning without a will. And that essentially we can open up, I'm saying we, um, the where the person died, a resident of such and such county. That circuit court is where the probate would be open, and essentially there's a window during which people can petition to be named executor, or what would more likely be termed the personal representative. Um, if you're getting interference in the background, I think we are having our office vacuumed. So if you're hearing anything, that's what that is. And so that process would start in the county in which the decedent lived and passed away. Um, During that time, other people can, well, nominate themselves. No, I should be personal representative. Or, hey, look, actually, there's a will. I have it here. I'm going to put this forth, and it names such and such person. Um, this is that process during which we probate what was the will of the decedent, or if the intestacy statute should apply.
We have a couple more great questions from the audience. V has it's a short question, but I bet it's a long answer. How to avoid the probate? Are there any benefits? I'm adding this part. Are there any benefits to avoiding probate? Every time you give this presentation, somebody asks this question. So I'm just so curious. Are there why does everyone want to avoid it, and how do we avoid it?
Sure. Can probate be avoided? Yes, yes. And the shortest answer to this is by the use of a living trust. And so to expand a little bit about what that is, that's essentially we have created that metaphorical red wagon. We put all our assets into this creation, kind of like a corporation, right? Can you put your finger on a corporation? No. It is a creation of the law. And what a trust can do is you put your assets in there and you have a whole article talking, or several, talking about where do these assets go upon my death. And as long as there's an instruction booklet on every single asset that you have, whether you have titled it to your trust, your home can be titled to your trust, um, or if this is the type of asset that can have a beneficiary designation. Upon my death, this goes to X person or X and Y. Um, and if X has predeceased me, instead it goes to Y. And as long as all of these assets do not end up in my name alone, right? They're either in the trust that has its instructions, or they are the type of asset that allows you to designate, give the instructions to that asset. There will be no probate because there's nothing passing through. Or if it is so minimal, almost any jurisdiction has an amount typically below 50,000, or even lower if it's 25,000, then that can be handed over without even an affidavit or anything. As long as the assets are so low, we will not need to open up probate. And so how do we avoid it? Yeah, that would be how. Now, benefits to doing so, yes, there are typically court fees. There are also required filings through probate, an initial list of all the assets called your inventory, and then periodic accountings. You know, are they still there? Have you distributed them? Can you account for all of the assets that you said were there in the inventory? And have they been distributed yet to the named designation, named beneficiaries? That takes time. It's paperwork. If you have hired a firm to help you with them, well, you know, you're paying that firm. We're very helpful, but perhaps you do want to avoid those costs. And so those are the considerations and why people might want to avoid that process.
Speaking of living trusts, Elizabeth asks, under a living trust, does the successor trustee ever take over from the financial and healthcare powers of attorney before the original trustee dies? For example, long-term incapacity. How does a healthcare power of attorney differ from a living will or healthcare directive?
Okay, a couple different questions in there. The first one seemed to be, you know, what is the operation of a successor trustee, say, in the scenario, you know, of declining health, specifically declining mental health, where a person, you know, loses capacity such that they cannot direct their assets. The trust itself will often and should, and ours do, have a little bit of an instruction booklet as to what constitutes incapacity, and the successor trustee will take over according to those rules. A general power of attorney will typically take over in a similar sense, and a medical power of attorney will take over in a similar sense as well. The direction of the assets by the trustee will be over everything that is in the trust. Again, our aim is to try to make sure that, well, pretty much everything is in that trust so that that successor trustee does have control over those assets. The general power of attorney will not be limited to the trust assets, though we did talk about the potential limits of a general power of attorney. Specifically, a good example is real estate. A buyer would be pretty hesitant to rely upon just a general power of attorney, even if it said that it extended to real estate. They would want to see a very specific power of attorney for sale of property. And so that would be a good distinction. Whereas if your home were titled in the name of your trust, a buyer would not necessarily have that hesitation. I think the final questions were about healthcare power of attorney versus medical directive, and the distinction there. Well, basically, the medical power of attorney will have the specific nomination of the people, the agents, whereas the advanced medical directive will talk more about the care itself, what procedures you do or do not want to undergo, and that kind of thing.
So we have been talking a lot about death, but Yolanda would like to talk about taxes. If someone dies without a will, say that word for me. I'm always very bad with it.
Intestate.
Intestate. If somebody dies intestate, what is Virginia's tax cut?
I will answer essentially the estate tax, which actually Virginia is often listed in those lists of best place to die. I know that's a bit of a counterintuitive list to be in a magazine, but Virginia ranks high on that list typically because there is no estate tax. There's no state estate tax, I should clarify, in Virginia. And so that would not be assessed. But as far as costs going through probate, a similar rule would apply as far as the the costs and fees associated with probate. I am taking a look at time. I do think that we are pushing past 8 o'clock there, so I wanted to make sure I didn't, as we've talked about Zoom going on too long, I didn't want to be one of those Zoom meetings that did go on too long. So I wanted to just make sure if there were any final questions, but it's probably about that time, isn't it?
All right, so we are going to end it there. If you have final questions for Bryan, where can they find you? Can you put your contact information back up on the screen for us?
Absolutely. I have a closing page there, although I was reminded that I only put my email on that one. So I am going to bring us back to the initial slide, which has more information. But I did want to just put up that slide also because I wanted to thank everybody for being here tonight. I want to thank Hannah, and I want to thank the Alexandria Libraries. We can't wait to get back there in person. And I do believe actually you are opening up. So again, thank you so much. And thank you to all of you. Do feel free to reach out at that email, though I am going to see if I can scroll us back to the very beginning and get the full contact information where you should feel free to give a call.
While Bryan looks for that slide, I'm just going to go ahead and promote an upcoming program. So tonight we talked about current law. I have a program on some more historical law coming up soon. On Monday, June 7th at 7 p.m., Dr. Peter Wallenstein is going to do a talk about some of his books, and he writes extensively about the court case Loving versus Virginia. So if you'd like to celebrate Pride Month with a more historical look to marriage equality, we'd love to have you. It's another webinar-based format where you'll be able to ask your questions, and we'll be in conversation with Dr. Peter Wallenstein on Monday, June 7th. A link to that event is in the chat box. And I know that some of you didn't get to ask your final questions of Bryan because we ran a little long, but please feel free to take down that contact information that you see on the screen and reach out. Do you have any final words for our audience, Bryan?
No, I want to just again thank you for your time, and I will be looking forward to those recommendations for restaurants and delivery from the chat box. Thanks in advance.
All right, thank you so much, everyone. Thank you, Bryan, for giving us some of your time, and thank you to everyone who decided to join us on a random Thursday night to talk about estate planning. I know it's not the most fun topic, but if you do like talking about this stuff, the first Saturday in June is our next Death Cafe. We'd love to have you. All right, everyone, have a good night.
Have a great night, everybody.